I said, I'm Dr. Phyllis Zealand, CEO of Knowledge Preservation. We're an information governance and data privacy global consulting firm. And we're going to start. Yep.
Hi, everyone. I'm Karina Clever, founder of Clever Compliance. I have should we do rounds of introductions first?
We'll introduce
as we talk. All right. So my message is kind of twofold. One is for the companies that store consumer data, and the second one is for the consumer. So I'll start with the company that stores consumer data. Classify it, know where it is, know how it's being housed, know which vendors are accessing it, and access NIST V2 standards is data processing, data storage, and data transportation, right? So make sure that you're able to talk about what's getting recovered and how long you're holding on to it. Watch out for data hoarding. We all love to data hoard. This is the equivalent of too much stuff in your closet with it falling out. There's no reason for you to hold on to data for decades. So from a consumer perspective, enact your consumer privacy rights. There are over 10 states now in the US that have consumer privacy rights for the consumer. Lock your social security number, lock your kid's social security number. Virgin social security numbers are wonderful for hackers because they establish credit on social security numbers that nobody's really checking. That kid hits college and goes to apply for student loans. They've got 3 delinquent snowmobiles in Wisconsin that now they can't pay for, and then college stops for several years while you're hiring the attorneys and trying to correct the credit. Do not post pictures of kids, videos of kids online on social media, please. You're creating a digital signature for them they have not opted into. You're also exposing them for digital theft, basically identity theft. So if possible, get off social media. Tough one, but social media, just during the LA wildfires, I had a family reach out to me. He had a strong digital social media presence and she did not. This was a LA Fire Department family. She had no fraud attempts. He, because he was on social media, had quite a few loans applied for through the SBA and relief funds under his social security number and identity that he knew nothing about, because he went out and he posted that he was affected by the wildfires. So kind of a two-pronged approach. 120 countries globally now have consumer privacy rights. State of California has a listing of data brokers. Data brokers qualifies a company as 50% or more of your revenue is from buying and selling data about consumers. If you have any more questions on any of this, I'm around all day today, so I'm going to hand it over to the next panelist.
Thank you, Karina. Yes, hi. For those of you who heard my panel discussion yesterday, you realize that regulatory compliance and privacy is something that I take a look at for a large corporate point of view. However, any company, whether it's large or small, really is affected by records retention and privacy best practices. So what we do is ensure that all of firms' compliance is legally defensible. And as I mentioned yesterday as well, we have read every law in the world for every vertical market and every jurisdiction. So that actually has privacy associated with every record series and record type that people maintain. So for example, to be compliant and make sure that privacy ensues, and for example, for our clients in the states, they are not as concerned about privacy, unfortunately, which Karina actually alluded to already. However, because of GDPR and regulations throughout the world, people are actually much more attuned to PII and PHI, which is obviously privacy both for the individual and in situations for healthcare as well. So what we actually do is explain to our clients that we have to understand every record series and record type that they maintain for every functional area. The foundation of what we develop is called a records retention schedule. Do many of you actually have a records retention schedule for your firm right now? Can I see a show of hands as far as that's concerned? Well, good for you. Actually, what kind of firm do you have?
It's heritage management, so we work with CRM, so compliance monitoring.
Perfect. Okay. Yeah, I mean, all of you should actually have the foundation of a records retention schedule and policy and procedures. And basically what that means is, in the case of litigation, you're not considered arbitrary by the courts, in addition to which you would have a schedule of how long to keep records, because after they maintain their regulatory compliance, they actually should be discarded, whether they're electronic and physical. Most of the time these days they are electronic, however, the physical components might still be around. And the people who actually should hold on to each of the documents are the offices of records. So when people have convenience copies because they're doing something with them, or copies of emails or something like that, they should be discarded. Otherwise, during discovery, and we have such a litigious society right now, they are discoverable, and that could actually cause millions of dollars worth of penalties. So what we make sure is that we conduct, and you should conduct also, needs assessment and gap analyses to actually ascertain all the record series and record types within each functional area of your organizations, and then associate records retention rules to them. You could certainly hire consultants to do that if you have risk people on site, if you have compliance people on site, if you have general counsel on site. They may be able to do some of the work for you. But I must warn you that if you start trying to find regulatory compliance and statutes utilizing AI, unfortunately, that won't work for you. We've actually done spot checks just to ensure that we're correct about things. And since we have a very large group of compliance attorneys who actually do our regulatory compliance and update everything yearly, but 80% of what we spot checked was not correct. So for people who say, oh, we can use AI now, it doesn't work at all, and you want to make sure that everything is regulatory compliant. I could actually talk about this forever, but just what I would love to leave you with is just make sure that you have a records retention schedule that actually talks about the jurisdictions where you do business and also your compliance situation specifically for your industry. If you're just in the US or North America, it would be one thing. If you do work overseas, because GDPR, as I mentioned, has been around for quite a few years in Europe now, and Europe is much more compliant than we are. I would say that Africa is actually more compliant, Asia is more compliant, and unfortunately with our new regime in Washington, I don't know how many of you actually listened to President Trump last night, but he was talking about slashing and burning regulations, and that's what people and I cringe about, because if that happens, then all of a sudden we have the Wild West, or actually within the Biden administration and previous administrations, at least we were further along with compliance as we are in Europe and other jurisdictions. If anybody is interested in learning more about this, because as I said, I could speak for weeks about this, and I actually wrote 4 books about it that have been published over the past couple of years, certainly find me later. I'm also around for the rest of the day. I'm going to pass this along to Ginny, and then if you have any questions, we'll leave a little time for questions at the end. Ginny?
Thank you so much. Yeah, thank you. So I'm Ginny. I have a marketing agency, so I'm going to talk about data rights. So it was really, really interesting. I love the people who are really, really into that every day in their job. As a marketing agency, of course, we deal with data. Now it's not my job. So I'm going to say maybe things a little less like technical, but more like day-to-day and what happened with my clients. So first, user consent. So something that is important is, I mean, every company who does marketing needs data. We need data. We need to know who are our potential clients. We need to know who are our leads, and we need to convert them. So data is really, really important in marketing and in any business, but we need also to make sure that we have consent. So I think it's going back to regulation, because we cannot just gather data and just say, oh, okay, it's this person, we can email them like forever. Especially text message. If you want to text message people and you receive maybe more and more marketing by text, because it is actually working, we need to make sure that we are, like, we have all authorization to actually text this person, and we have opt-out option so this person can refuse the text, because there is not, it's very hard to, on the phone, to actually say no to a text. We usually receive them, either in or not we want them. So it's having, the company having the opt-out option is very, very important. I'm sorry, it's not. Another thing is, and you certainly know that as a company, a lot of companies gather data, and then instead of using the data for themselves, they sell them. So it happens a lot, and it is a choice to sell or not the data. If you sell the data, you have to tell the users. Most of the companies say, just, a little line at the end, and just, hey, give us your emails and we will do good of it. And then there's a little line saying, we're going to sell your data. So it's very important to, first, to if you do make this choice, because there is money involved, you have to tell your users. You can also choose not to. I'm working with people who are working with US military, and military people don't like their data being sitting around. So we have actually shoes, it's called must-wants, it's for people who are PCSing. We actually choose, and the CEO choose as a trust to not sell data. So we gather data because we need data from our users, but we don't sell them. We don't sell the data to any realtors. We don't sell the data to anyone. People can find professional on our platform, but we don't sell the data around. So I think it's a choice, and not selling data today is actually a very strong company value that we should put everywhere if we do it, because it's very important to have that. And then maybe my last point will be about anonymous data, because when we do marketing, we need data from users, yes, but we can also work with anonymous data. We don't need to know the name of the people who go back and forth on our website. We can just know if they are on mobile or web, and just analyze completely anonymous data, and that's what I prevail in my marketing. So if we don't need to know the users, and we just are trying to make like improvement, so I do what I call UX marketing, so it's marketing linked to user experience. And for everything that is user experience, honestly, I always tell people, don't give me the name of the people, don't give me the phone number we'll call. I don't need that. What I need to know is what they did on the website, which page they went. I look up the heat maps, I look up everything, but I don't need to know who did that. So I think it's very important to be like compliant first, and then to see what do I really need, and then to not gather and hold on data that are completely unnecessary on your server, and just make the right choice. So I think I will end up with that, which we come back to more tech. It's much less technical, but I think it's all related, and yeah, I will pass on that. Thank you.
No, it's gonna be hard to top. So apologies, guys. So I'm Anthony Cacciapoli. I am the principal and founder of Cacciapoli Consulting Group. What I mainly do in a nutshell is I help companies, whether enterprise or startups, with their ad technology stack, like which ones are right for their business, what gaps they can solve with certain technologies, as well as how to handle data and also identity graphs. So as you can imagine, there's a lot of privacy laws in place to make sure those data sets don't get leaked. But from my perspective, and going over onto the publisher side, for instance, so the past 4 years I've been on basically the data owner side, if you will. So if you think about like how many times you guys go on websites, right? How many of you go on like New York Times or Business Insider or Washington Post? Like just a quick raise of your hands. Yes, almost everybody. Now, how many of you gotten that annoying pop-up that says accept cookies or manage cookies, right? Not even reject. And how many of you get confused by what you're actually managing? Like, you have a list of names, you probably have no clue what they are. Trade Desk, Xandr, Google Analytics, all these different types of cookies. And you're like, well, I don't know which one it is. And then you get so frustrated, you end up hitting accept, right? That's not a good practice, and that's what laws are supposed to prevent companies from doing. However, there needs to be some kind of balance between what the government says, what a business needs to operate, and ultimately what the consumer is supposed to receive, right? So if you look at those three entities, there is a fundamental information gap. Because when the government says, and I'm going to use like a blanketed one, right? Data sharing is like prohibited with certain identifiers, right? IP address, emails, etc. But when you look at how to interpret that law for a business like a Business Insider or a Wall Street Journal who relying on information to create a customized or personalized experience, whether it's a subscription experience, whether it's just surfacing the right suggested content, right? Something that makes a user want to come back. That interpretation ultimately gets obfuscated, right? You don't know how to enact it without disrupting the user experience. And then what the user ultimately sees is something that they just like I have to accept or manage, like I don't know what to do, right? And then not to mention, if you refresh your cookies or 30 days pass, you have to do it all over again, right? And I'm sure all of us here have been to Europe, for instance. How atrocious is that internet experience? Raise your hand if you hate it. All right, so anyway, with that in mind, right, the publisher is very much lacking knowledge on how to execute this, right? Not to mention when every state creates its own privacy laws, now they have more stress, anxiety, and lack of resources to actually implement a solution, right? So as a publisher, right, gotta stop saying right, but anyway, as a publisher, you have to strike the balance of what is necessary from a data perspective to operate. You need insights about your users, especially if you have an identity graph. Identity graph is basically, actually, how many people are familiar with identity graphs? Oh, no one, all right. Okay, so basically, yeah, think of it this way, right? There's a household, there's consumers, and then there's devices. If you have a consumer, you know which household they belong to, you know who lives in that household with them, and you know all the devices they use. That identity graph helps us understand not only who you are as an individual, again, anonymously for the most part, right? We're not looking at your first name, last name, physical address. We're looking at a household 1, 2, 3, if you will. Now, that consumer, you have all these identifiers that are transactionable, right? Because a lot of publishers rely on these data points to monetize on the advertising business. And those identifiers need to be sent or shared with entities outside your four walls. So think of companies like the Trade Desk, for instance. They are the biggest programmatic buying arm in the industry. But they can't transact on first-party cookies, for instance, because that means nothing to them. They need to transact on something that's universal, mobile ad ID, hashed email address, things like that. So in order to make money, you need to find a commonality. But if there's really, really big restrictions on these identifiers being shared, then you're actually putting publishers out of business. Because the thing is, what you're ultimately asking the publisher to do is shift towards their status quo to a more direct advertising business. And what that means is, with your limited resources, right, everyone's scaling back, you have to now go out and call agencies or call brands and say, hey, buy with me in a direct capacity. And that's a lot of work, especially if you have a small sales force. So not only is traffic going down and your advertising is going down, your advertising monetization capabilities are going down. It's hard to ask publishers to do that all in the name of privacy, right? So I think what needs to happen is a meeting of the minds where the government, the buyer, the companies, and the users come together and go over what is like the least common denominator requirement to make businesses operational without causing them to go bankrupt or put so much strain on them where it's like a slow death, right? So from my experience, that's been the crux of the problem, right? There's been no end-to-end accountability or end-to-end communication. So yeah, I'm happy to talk more about that because I know a lot of people are probably in the same boat. But yeah, that's my spiel, and I'll pass out to Shimmerlin.
So hi everybody, my name is Shimmerlin Sidoni John from beautiful St. Lucia. Like I love to say, I am a global brand strategist and I help build influence and trust for leaders so they could attract the best talent, clients, partners, investors. And some of you are probably wondering, okay, so what are you doing on this panel today? Because when we had our first meeting, you know, that thought came to mind. But here's the thing. With everything that we've discussed today, if the leader does not have the ability to communicate the importance of data to the key stakeholders, then isn't that going to diminish the way in which they trust us? Yes or no? And how many of you have actually thought about using yourself as a leader and the way you communicate the importance of that data, you know, to your clients and what your organization represents. Communication is very important. Very important, and it is a way in which you can accelerate that trust. Wouldn't you agree? But the thing is that we take it for granted. In this digital age, people want real connections. And yes, it's important to position yourself as an organization which values data privacy and values data compliance. But do they really feel that? Because the truth of the matter is, any organization could say that, but how do you truly differentiate yourself? People need to have that connection with you, and the best way to do that is by the founder, the CEO, the executive in here using the most important asset an organization will ever own, you, that brand called you. So I know I'm shifting the perspective from data privacy, etc., from as a corporate asset, which is critical, I'm not denying that, but to something that's more personal, something that's more humanized. And I'm sure everybody here could relate to that. Thank you.
Can I add 2 words to that?
Mhm.
Thank you for that. So, as a leader, and I'm going to tag on to what you're saying,
Thank you.
it's our duty to establish policies and guidelines for our workers, whether our workers are employees, contractors, temporary staff. If you have not published out policies, guidelines, standards, procedures, whatever you want to call them, write it on a napkin. You have to provide instructions for your workers on the importance of handling data, how you handle data, what your position is, and also please write an AI policy. For God's sakes, all your people are using them, right? They're using something. If you haven't blocked it on your firewalls, if you're not actually removing nefarious extensions, right now there are 33 nefarious extensions siphoning personally identifiable data off of Google browsers. If you need that list, come and see me, please. But, and 5, last I checked, 5 of them were AI extensions, and I think 4 VPNs. So you need to provide your folks information and guidance on what's important to your company and expect the same of others, because if you have not provided those guidelines, they think it's all free for all, right? And they're using AI day and night, all day long, on whatever they can find, because it's been touted as this magical, mystical silver bullet pill that fixes everything. But the reality is it's only as good as the data put in there, and the data put in there is usually not that great, like Phyllis said. So, so just keep that in mind as leaders to provide that guidance.
And I'm going to add, from a communication perspective again, the way in which you communicate that information is extremely important. It has to resonate. If it doesn't resonate, they're not going to trust you. Your team members, your stakeholders. So a lot of the times, even through communicating, leaders tend to use a lot of industry jargon. And I'm not saying it's not important. It is. But at the end of the day, you need to understand the end user. How do we get that information across to them in a way that it drives results? Because that is what you want. That is your end goal. So it's important that when we, from a speaking perspective, and even from a writing perspective, when disseminating that information about data privacy, policy, etc., your words have to resonate. It has to be intentional, and they need to understand the bigger picture. Like you said, why? What are the implications? That's what we're working towards. That's how you build trust.
I want to also add, so I would take it a step back and say, how do you make the C-suite accountable, period, for a data privacy type of workflow? Because no one's holding them accountable. But if there's any breach, leakage, et cetera, it's never them accountable. It's always the people who are executing, right? Because there's this, and I don't know if you guys feel it too, but there's been some kind of scapegoat environment lately. But I feel like leadership needs to take accountability for what they do for the company, and privacy is a big one. So I would pose this question, and there's no right or wrong answer, but who should hold the C-suite accountable for these things?
And actually, from a regulatory compliance point of view, the C-suite is now held accountable.
Exactly.
They
Yes, the C-suite is now held accountable. And as Sherilyn just said, when we write policy and procedures going along with the records retention schedule, we interview representatives of all the departments, of all the functional areas. But in addition to speaking to the leaders of all the departments, we also speak to representatives who are an echelon below. So when we write the policy and procedures, as you so
Exactly.
yes, so we actually use their buzzwords, their buzz phrases. We use the actual naming conventions for the documents and so forth, so everybody understands them. So as you can see from the panel, even though we're talking about state, we're talking about global, we're talking about communication, we're talking about publishing, we're talking about marketing, there are so many aspects to regulatory compliance and all of these things these days that we could have another 10 people up here that this really speaks to. But as Anthony mentioned, people don't really know this, but when it started with Sarbanes-Oxley many years ago, which was one of the first regulatory compliance statutes that actually held the CEOs and other C-level people basically, if they weren't in compliance, they could go to jail. And that actually still happens these days. As I said, regulations are changing, so I'm not really sure what's going to be happening in this country. But I do know what's happening overseas. Canada, South America, Europe, Asia, all the other continents, they will all be held accountable. And unfortunately, the United States is going to have a problem because multinational companies that have corporate base in the U.S. still have to be in compliance in all the other countries that they do business. So whereas when we develop records retention schedules right now, we default to the longest retention period, when we're going to have to really take a look at most of the schedules, if not all the schedules that we've developed through the years, because they won't really be in compliance anymore. So all of this, taking a look at distrusting regulations and slashing and burning them is only going to bring people like myself and Karina, who do this for a living, with a myriad of problems for their clients because they really won't know what to do. They want to be in compliance, and if they're not, they can all of a sudden get litigated against. So this is really opening a major can of worms. So I think this topic today was really important, but also to see not just from regulatory compliance that the two of us do, but in 3 other industries which have, feed into what we do. It's really a universal problem now. And if we do the same program, the same panel even for next year, it's going to be very, very different, unfortunately. And we'll have a lot of perils and pitfalls to discuss. Anything anybody else wants to mention?
Agreed. And I think I would add, though, just listening to everybody here, in developing policies, strategies, etc., don't operate in silos. Bring in the various stakeholders, bring in your communications team, have them develop a 360 engagement plan, including all stakeholders. That's going to help minimize risk. It's going to help hold people accountable, because it's true to you, ask who's going to hold the C-suites accountable, or anybody. From a leadership perspective and the team, have it document your 360 engagement plan and honor it, follow through it, but it has to be a part of your policies, etc. Don't do it without having that. That would be my key takeaway from a communication perspective.
Anyone else? Can I add one more
Go
thing?
ahead. Yeah, sure.
If you work in a publicly traded company, please drill the Securities Exchange Commission 4 business day filing requirement in case of a material breach. So very, very important. Sometimes you drop things into legal and it's 45 days later, and something comes out the other end and it goes into finance and it's 72 days later and it comes out the other end. Come up with a code word and drill it. Drill it during your DRBCP. Purple dinosaur, doesn't matter. Cookie ice cream. Come up with a word in the subject line that every single receiving department is going to know that they have to move it fast.
Yeah.
Because here's what's happening, folks, and this is absolutely important to understand. The person sitting in the SOC, the person sitting in the NOC, the technician working on that ticket knows that there's a material breach and it's serious. They also know You drop something into legal and it's 45 days later. So what are they doing? Hello, SEC. And they're protected by whistleblower laws. So they're calling the SEC for you guys within the 4-day requirement. And next thing you do, knock on the front door. Here come the regulators. Why didn't you let us know you had a material breach? Oh, well, we dropped something into legal. We're still waiting for it to come out the other end. So as part of your DRBCP, drill that workflow. Come up with some sort of call it 1, 2, 3, subject line 1, 2, 3, 4. Doesn't matter what you call it. Make sure that all of the departments know about it and they know how to move that through quickly. Because what is the regulator going to come in and check? Show me your incident response plan. Why haven't you actually notified us within the 4 required days? You're publicly traded. Now you're in violation. Now you have a bigger problem.
Yep. And regulators don't care about politics.
No, they don't.
So if you were arguing amongst yourselves, too bad. They're going to come in and slam you.
Another word of warning that I would like to give everyone is oftentimes people develop their own policy and procedures within their own functional areas. We find this all the time when we actually are engaged to develop a retention schedule and legally defensible policy. We actually ask the functional areas for any retention schedules they might have developed themselves, any policy and procedures, and we find that for the most part, they're inaccurate and not legally defensible. So just be careful. I see that a lot of you don't have records retention schedules and policy and procedures in place. And I just warn you that start thinking about this. Your C-suite should be thinking about this. You should actually have a steering committee of representatives from the C-suite and also representatives of all the functional areas. We talk about GRC, governance, risk, and compliance. That's really the buzzwords for today, and that's something that I would love you all to remember for today, too, from what we're talking about. GRC is just so important, and that's actually what the GDPR in Europe actually established to begin with, and what has really had legs into all the other jurisdictions and all the other continents. Unfortunately, I'm very sad because I've been doing this for 40 years, and compliance has really come to the fore. It actually started right after the disaster in the World Trade Center when people couldn't find their documents, they didn't know what to do, things weren't scanned, things weren't sent to other locations and so forth, and they were starting from scratch. At that point, I am based in New York, and people reached out to me afterwards and they said, Phyllis, you had such a great idea for a company. Well, I've been doing this for 40 years, but people just never thought about this before, but now they are. So just remember that compliance is really important, and you should really take a look at what you have right now. Certainly, if you ever need just some basic hints and so forth, you can certainly reach out to me at knowledgepreservation.com. I'll be happy to give you some free advice because I really want everyone sitting here today and everyone in general to be in total compliance. So that being said, I'm still very excited by what I do, and it's an industry and a field that's growing all the time, and I just want that to be a takeaway for me for today. Anybody else want to mention something in closing?
For me, I think I want to end by saying that trust is the new currency. Trust is the new currency, and no matter how many policies that you have in place, if you can't articulate it in a way, like I said, that resonates and that drives results, it is work that is futile. So understand how you could put the you into enhancing your data policies, compliance, and do it in a way that you empower your teams and other stakeholders to be accountable and drive those results. And to add, if you're interested in understanding how you as a CEO or founder could enhance your communication for speaking, etc., you can reach out to me after the conference. I am on LinkedIn, Shimalin Sidoni John, and let's have a chat to see how we could work together. Thank you.
And
Any
was-
questions?
sorry, I just have one more last thing. If you're not confident enough to put your job on the line for your company's privacy, you should probably do a due diligence. So that's kind of like put yourself in that position.
It's a good point, Anthony.
Yes, the
questions from anyone?
For a multinational firm that is doing business in Sudan or Qatar or Saudi Arabia, do you have any high-level comps or case studies, either from a current or historic standpoint, for a firm that's really doing compliance the right way?
100%. 100%. We have white papers available for everything that you're articulating, and we'll be happy to share them. My senior team and myself have been doing this for 30 to 40 years. My senior team are all people that I've worked with, that we've worked with together over the years, and it is a global firm, so we'll be very happy to share all of that. And that goes for all of you. If you're ever looking for any white papers, any additional information, any case studies, we'll be very happy to share that, because two of my friends in the back here told me yesterday when we were talking about something that we were recording for a podcast. I'm as enthusiastic about this today as I was when I started out 40 years ago. So anything I can do to help and just bring compliance to everyone who listens to me, I'll be just very happy to help with that. Great question, and reach out to me. I'll be happy to help. Any other questions?
Looks like the next team's here.
Yeah.
Yeah? All right. Thank you, everyone.
Thank you,
Thank
everyone.
you.
Thank you.